Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at a recent administrative decision by the National Labor Relations Board. In Murphy Oil and Sheila M. Hobson, the National Labor Relations Board reviewed its previous decision in D.R. Horton, which held that class action waivers and employment arbitration agreements violate the National Labor Relations Act. The board's decision in D.R. Horton was later reversed by the Fifth Circuit Court of Appeals, and its reasoning has also been rejected by several other circuit courts. In a 3-2 decision, the board in Murphy Oil reaffirmed its previous holding and concluded that the arbitration agreement at issue violated the NLRA by prohibiting class proceedings. Section 7 of the National Labor Relations Act provides that employees shall have the right to engage in concerted activities for the purpose of mutual aid or protection. Under Section 8A1 of the NLRA, it is an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of rights guaranteed in Section 7. The NLRA applies to most private sector employers, but does not apply to federal, state, or local governments. Employers who employ only agricultural workers, and employers subject to the Railway Labor Act. The board determined in Murphy Oil that the rights guaranteed by Section 7 are substantive, not procedural rights, and there is no basis to carve out concerted legal activity as being entitled to less protection than other concerted activity. According to the board, mandatory arbitration agreements that bar employees from bringing joint, class, or collective workplace claims in any forum restrict the exercise of the substantive right to act concertedly for mutual aid or protection. The board therefore determined that the employer-imposed individual agreements that purport to restrict employees' Section 7 rights, including agreements that require employees to pursue claims against their employer individually, violate the NLRA. The board further concluded that its decision does not conflict with the Federal Arbitration Act or undermine its policies. In support of this position, the board offered the following rationale. Number one, such a finding treats an arbitration agreement no less favorable than any other private contract that conflicts with the federal law. Number two, the NLRA Section 7 right to pursue joint, class, or collective legal action is a substantive right and not merely a procedural right of the sort found in other statutes. Number three, not only does the text of the FAA fail to establish that an arbitration agreement inconsistent with the NLRA is nevertheless enforceable, but the savings clause in Section 2 of the FAA affirmatively provides that such a conflict with federal law is grounds for invalidating the agreement. And number four, even if there were a direct conflict between the NLRA and the FAA, the Norris-Laguardia Act, which by its terms prevents enforcement of any private agreement inconsistent with the statutory policy of protecting employees' concerted activity, dictates that the FAA would have to yield insofar as necessary to accommodate Section 7 rights. After concluding that its previous decision in D.R. Horton was correct, the board held that the employer had violated the NLRA by requiring its employees to forfeit the right to bring a class action. Due to the conflict between the board's decision and circuit court's rulings, this issue is ripe for review by the U.S. Supreme Court. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In Integrity Staffing Solutions v. Busk, the United States Supreme Court issued a rare unanimous opinion in favor of employer Integrity Staffing Solutions. The Supreme Court held that the time employees wait to go through a required security screening after their shift is not compensable under the Federal Labor Standards Act of 1938 and the Portal to Portal Act of 1947. Integrity Staffing Solutions employs individuals to retrieve purchased products and packages those products for delivery to Amazon customers. After each shift, employees are required to complete security screenings, whereby they must remove their wallets, keys, and belts and walk through a metal detector. Employees wait approximately 25 minutes each day to go through this security screening, which is minimally staffed. In this case, a group of employees filed a class action against the corporation alleging violations of the FLSA and Nevada's state labor laws. They argued that they should be compensated for the time they spend waiting to be screened because the screening process is intended to prevent theft and therefore occurs solely for the benefit of the employer. The U.S. Supreme Court held that the time employees spent waiting for security screenings is non-compensable because the screenings are post-preliminary activities under the Act, which exempts employers from paying employees for activities which are preliminary to or post-preliminary to their principal activities. According to the court, security screenings are not integral or indispensable to the principal activity of assembling and packaging orders in the warehouse. The corporation could have ceased conducting security screenings and it would have had no impact on an employee's ability to fulfill his or her duties. Therefore, the screenings are not integral or indispensable to an employee's principal activities, and the employees need not be paid for this time. This case helps to clarify what types of employee activities require compensation under federal law. However, it is important to note that California courts have consistently held that hours for which an employee has been hired to do nothing or merely wait for something to happen are hours subject to the control of the employer and constitute hours worked. Accordingly, a California employer would likely be required to compensate its employees for the type of activities and waiting time discussed in this case. In Curley v. City of North Las Vegas, the United States Court of Appeals for the Ninth Circuit affirmed the trial court's decision to grant summary judgment in an action alleging employment discrimination and retaliation in violation of the Americans with Disabilities Act, or ADA. Plaintiff Michael Curley was an employee of the City of North Las Vegas from 1996 until 2009. Curley's disciplinary record reflected that, throughout his employment with the city, Curley received many oral and written reprimands for a number of issues, including verbal altercations with coworkers, damaging city property, making several threats of violence against coworkers, and making constant complaints and negative remarks against his managers and the city. In December of 2008, Curley filed a charge of discrimination with the Equal Employment Opportunity Commission. The charge alleged that the city had denied Curley's request for an accommodation of a hearing impairment. In January of 2009, Curley made a second request for an accommodation for his hearing impairment. Shortly after this second request for accommodation, Curley was involved in another incident with a coworker. The incident prompted the city to place Curley on administrative leave and launch an investigation into his behavior. As part of the investigation, the Human Resources Department interviewed city employees and asked about their interactions with Curley. The interviews revealed that Curley had repeatedly threatened his coworkers and their families, and that he regularly conducted personal business while at work, sometimes spending up to 3 hours a day on his cell phone. As part of its investigation, the city scheduled Curley for a fitness for duty evaluation, which assessed only whether Curley could return to work and whether he was a danger to himself or others. The doctor who conducted the evaluation determined that Curley was fit for duty and was not a danger to himself or others. At the conclusion of the investigation, the city conducted a hearing, during which it decided to terminate Curley's employment. A memorandum explaining the termination included the following charges: non-performance of duties due to excessive phone calls, intimidation of coworkers by threats of violence, conducting and soliciting personal business on work time, and making disparaging remarks about his supervisors and the city. Shortly after his discharge, Curley filed a charge with the EEOC alleging discrimination and retaliation under the ADA. After receiving a right to sue letter from the EEOC, Curley filed suit. The city brought a motion for summary judgment, which the trial court granted. In reviewing the trial court's decision, the Ninth Circuit determined that Curley failed to raise a genuine issue of material fact as to whether the city's reasons for discharging him were pretextual. Curley attempted to show pretext by pointing to the results of his fitness for duty evaluation. Curley contended that the city's decision to fire him, despite the conclusion that he was fit for duty and not a danger to himself or others, created a genuine issue of material fact as to the credibility of the city's stated reasons for firing him. The court disagreed with Curley's position for two reasons. First, the city explained that it fired Curley because of the threats he had made in the past, not the danger of future violence. Second, the court stated that even if the fitness for duty evaluation somehow undermined the credibility of the city's stated concern about Curley's threats, the city had put forth several other reasons for terminating his employment, and Curley had not attempted to refute those reasons. Curley also argued that because the city tolerated his bad behavior for years before his recent protected activity of filing an EEOC claim and making an accommodation request, his discharge must be retaliatory. The court stated that this argument wrongly assumed that the city was aware of the severity and scope of Curley's misconduct during the years in which it refrained from terminating his employment. On the contrary, it appeared that the city was not aware of the full extent of Curley's misconduct until the investigation, which revealed several additional, independently sufficient bases for Curley's discharge, which Curley did not contest. Finally, Curley argued that the fact that the city fired him within 2 months of his protected activity was itself evidence of pretext. While it is true that very close temporal proximity between a protected activity and an adverse employment action can be sufficient evidence of a causal link between the two, the court stated that the new information revealed by the city's investigation defeated any causal inference that might otherwise follow from the temporal proximity between his protected activity and his discharge. Because Curley failed to refute the city's legitimate explanations for the adverse employment action, summary judgment was appropriate. In Walgreens Company overtime cases, a California Court of Appeal issued a ruling in favor of California employers with respect to the provision of meal and rest breaks, affirming the trial court's denial of class certification. In doing so, it bolstered the application of Brinker Restaurant Corporation versus Superior Court as controlling law for California meal and rest break policies. Walgreens is a national drugstore chain with locations throughout the country. Lead plaintiff Daryl Collins was an employee of Walgreens and filed suit against the company, alleging that a class should be certified consisting of all similarly situated employees that had been denied proper meal and rest breaks. Collins' motion for class certification was premised on the theory that, while Walgreens' stated meal and break policy was proper, the actual practice and application of the policy was both illegal and consistently applied across the entirety of the proposed class. In 2012, the California Supreme Court issued its much-anticipated decision in Brinker. Brinker was a victory for employers with respect to its analysis of the duty imposed on employers to provide meal and rest breaks. Specifically, the Brinker court ruled that employers need only make available such breaks. They have no duty to ensure that these breaks are actually taken. In its ruling, the Brinker court stated that an employer is only required to relieve employees of all duties and provide them with the opportunity to take a break. The decision of whether to actually take the break is left to the employee. Applying the ruling of Brinker to this case, the Court of Appeal found that Walgreens employees were provided with the requisite opportunity to take their breaks. While numerous putative class members indicated that they skipped or delayed breaks, generally out of a desire to go home early, such actions are permissible. Based upon the weight of the evidence demonstrating that Walgreens had complied with the Brinker standard, coupled with the dearth of evidence in support of Collins' motion, the Court of Appeal affirmed the trial court's denial of class certification. This decision confirms that employers need only ensure that requisite breaks are made available to employees. The decision to skip or delay a break is left to the individual employee and cannot form the basis of a claim against the employer. However, employers should ensure that their meal and rest break policies are legally compliant and that managers and supervisors receive appropriate training in connection therewith. Finally, a California Court of Appeal recently expanded whistleblower protection to an employee mistakenly believed to have reported illegal activity. It is well established that California law prohibits employers from discharging an employee in retaliation for reporting illegal conduct. In Diego v. Pilgrim United Church of Christ, a California Court of Appeal expanded that principle, ruling that an employer is liable for wrongful termination when it discharges an employee because of a mistaken belief that the employee reported illegal conduct. Pilgrim United Church of Christ hired Cecilia Diego in 2002 to work in the preschool Pilgrim operated. In August 2011, a co-worker advised Diego in confidence that she had reported a foul odor to the California agency overseeing preschool safety and licensing. On August 19, 2011, representatives of the licensing department conducted an unannounced site inspection of the preschool. The identity of the caller was not disclosed to Pilgrim. Diego alleged that on August 23, 2011, Pilgrim's director questioned her on the role in the report to licensing and indicated that she believed that Diego was responsible. Diego denied any involvement. 3 days after this exchange, Pilgrim discharged her on the stated grounds of insubordination unrelated to the licensing complaint. Diego claimed that Pilgrim's true motive for firing her was Pilgrim's mistaken belief that she had reported violations to the licensing department. Diego sued Pilgrim on the ground that Pilgrim wrongfully terminated her employment in violation of public policy. The trial court granted summary judgment in favor of Pilgrim pursuant to the argument that because Diego had not actually reported any misconduct, she could not be considered a whistleblower. Diego appealed the trial court's ruling. The Court of Appeal reversed, finding that Diego's claim was sufficiently tethered to the fundamental public policy of encouraging employees to report illegal activity. The appellate court noted that because of the chilling effect of retaliation against employees who might report illegal activity is both severe and harmful to the public, the protection afforded to employees should be broadly construed. The fact that Diego had not actually reported illegal activity did not change the fact that her discharge, if actually retaliatory, would send an explicit warning to coworkers of how Pilgrim would respond to whistleblowers. The chilling effect was the key public policy concern, not the fact that Diego had not actually notified law enforcement. The appellate court emphasized that employers are already barred from preemptive retaliation, where an employee who is viewed as likely to report misconduct is discharged before he or she does so. The same principle applies to cases where the employer's motivations are similarly retaliatory. That is, employers should not be allowed to retaliate against employees they believe have or will report illegal activity as a means of suppressing these disclosures. This case serves as a reminder to employers to implement and enforce strict policies against retaliation in the workplace. All employees, especially supervisors, must understand that reports of illegal conduct, if made in good faith, are strictly protected. Furthermore, employers should always remember that when reports of illegal conduct are made, the employer's actions will be closely scrutinized. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jleyton@petitcone.com. That's all for this quarter's legal update. Thanks for tuning in.